Welcome back to the Emily Show, Monday edition, probably on a Tuesday this week because I recorded this episode very late because the lawyers are out of control this week and we have so much to talk about. Is today going to be a deep dive into all of it? No. Do we have time for it to be a deep dive into all of it? No. But are we going to get into it? Oh, yes, we are. Why? Well, Diddy caught a superseding indictment that I'm sure his lawyers are going to be thrilled about. We have some updates in the Karen Reed case ahead of another hearing in court coming up on Thursday, February 6th. We have a hearing coming up probably before this episode airs, but after it records because podcasting on Monday, February 3rd. And, well, Sarah Boone had some questions for the court that y'all have asked me about, and we need to talk about that too. So for all of you who are new to the Emily Show podcast, if you're watching on YouTube, there are timestamps down below to get to the stories you care about most and never miss an episode with the Law Nerd app at lawnerd.com. Let's get into it. Hey there, before we get all the way into it, I wanted to make a note that there is an addendum. We pushed back this episode knowing that this hearing is something you want to know about. So we're just adding an addendum here. So if you hear me say, well, they're going to court, I've got you covered at the end of this episode. Let's get into the rest of what I recorded a few days ago. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. Let's get started with some quick updates. And for those of you that have watched the Quick Bits episodes or listened to them on your favorite podcasting app about the Karen Reed case, I talked about the hearing that was in court in Massachusetts on Friday, January 31st. And surprise of all surprises, though this judge does not rule from the bench, the court did rule late in the day on Friday the 31st. I know. I was surprised as well, but let's talk about what those rulings were real quick. And the episode where I summarize that hearing will be down below, but it was a hearing to have a hearing. And there are a lot of things still pending as this case speeds towards jury selection on April 1st, 2025. One of the things that the court needed to decide quickly on the 31st was whether or not there would be another evidentiary expert hearing like we saw with Dr. Russell. And there will not be. The court determined in a memo ruling that she would rule on the Commonwealth's motion to exclude certain opinions of the defense tech expert without having a further Daubert Lanigan hearing. Look, that's not what those types of hearings are for. I am not surprised that the judge said, I don't need to have this hearing. It really is a question of experts disagreeing, and that is for the jury to decide. That is not really a question of sufficient methodology, and so the court is not granting the evidentiary hearing the Commonwealth asked for, and we will see the court ruling, I expect, more thoroughly on whether or not those opinions will be excluded down the road. I imagine that the court is leaning towards these expert opinions are not going to be excluded. These are proper area for expert opinion. There's been plenty of notice, and this is what you bring in other experts for. This is truly a battle of opinions. That is what experts do in courts all the time. So I think we'll see that in a more thorough opinion down the road. The court also ruled on a reconsideration motion with regard to journalist Gretchen Voss. And one of the things the court had been asking Voss's attorney about was the notes. And the court had ordered that unredacted parts of an interview between Gretchen Voss and Karen Reed be turned over to the prosecution because some of that interview had not been turned over. And the court had ordered, it seemed like all of the notes be turned over, and Gretchen Voss's attorney, or the attorney for the Boston Magazine, asked the court to reconsider that, saying that these were private, they should be protected for the journalist, and these were notes of impressions and off-the-record conversations, and those should be kept private, and provided the notes to the court to review in camera, which means in chambers, for the court to review themselves. The court did so and actually narrowed down her prior ruling and said that the notes of the off-the-record conversation would not need to be turned over, that the Commonwealth had not made a compelling argument to do so, and that the on-the-record conversation could be turned over and the parts that had been redacted would be turned over, but that was it. So it was interesting to see that the court actually did narrow down that prior ruling and that the motion for reconsideration was in fact reconsidered. Color me surprised. So now what happens on Thursday? Well, we know the court's going to take up the issue a bit more of what the heck happened when the defense expert went to Massachusetts to download original video from the DVR and it was not there. That's going to come up on Thursday, amongst other motions. We are going to hear a bit more about the motion to dismiss, though it won't be filed yet. And the court's going to try to use that court time on Thursday to make sure that discovery is done. The Commonwealth said they should be done with discovery, but I think the main issue we're going to hear about Thursday is what happened when the defense expert went to Massachusetts and whether those costs will be attributed to the Commonwealth, and the Commonwealth will have to pay for that over $12,000 rather than Reed paying for it. And speaking of cases that are after trial, we need to talk about Sarah Boone very quickly because I got questions from y'all. For those of you that did not follow along, the Sarah Boone case was a trial that I covered at the end of 2024 that took place in Florida. She was accused and then convicted of the second-degree murder of her boyfriend, who she zipped into a suitcase and left there, and was subsequently sentenced to life in Florida and is now beginning the process of appeal. Sarah Boone, for a brief period of time, represented herself, but even when she didn't, definitely was not hesitant to go ahead and tell the court what she was thinking. And she actually reached out to the clerk of court to say, hey, why haven't I heard from my appointed appellate attorney yet? So even though Sarah Boone is not technically representing herself because appellate counsel was appointed, Sarah Boone typed up a letter to the court saying, excuse me, why have I not heard from my appellate counsel? Sarah Boone says, quote, the last entry on the docket in the case shows that Joshua Adams ESQ was appointed to represent the defendant on December 18th. By defendant, she means herself. However, she has not received any correspondence from him, and her application of indigence to be appointed an appellate attorney was not filed with this court until December 23rd. So on January 20th, 2025, Sarah Boone was like, yo, what's going on? That wouldn't be unusual, except the clerk of court responded, which raised some questions. On January 29th, the clerk of court responded to Sarah Boone and said, in response to your correspondence dated January 21st, 2025, the following applied. Attorney Joshua Adams has been appointed to represent you for appeal. However, at this time, no notice of appeal is on file. The reason it matters is because her sentence became final on December 2nd. You could say maybe within a few days of that before it's officially recorded, but the deadline to file notice of appeal within 30 days is a pretty stringent deadline. And it's generally trial counsel that will file the notice of appeal, even if appellate counsel is coming in, because notice of appeal is literally that. It's a placeholder. It's a, hey, we're appealing. It's a very standard and pro forma yo-yo, we're appealing. And so for the court to respond and say, by the way, we haven't received a notice of appeal outside of that 30-day deadline does raise some interesting questions. So when I went back to look at the docket as I was recording, what I found is that there is a December 18th notice of appeal that was filed by her trial counsel. This was filed by her trial attorney, James Owens, and the e-filing stamp shows December 18th at 4:58 p.m. So I don't know if this got lost, if this got digitally sent elsewhere, but I found it on the docket and took a look. The sentencing, they say Sarah Boone appeals to the District Court of Appeal on December 2nd from the sentence and judgment. So this notice of appeal was filed. If it is a clerk error or a filing error, that's not going to be charged against her. However, I imagine that getting that notice back from the clerk of court is not going to be Sarah Boone's favorite, but it is probably not going to be a large issue. But the docket now has a note that says received by the clerk on January 31st, 2025. But the docket also shows that it was filed on December 18th. I think this is likely a digital error. I don't think a court is going to say there was a digital error. You're outside of the time frame, especially since that docketed item by Attorney Owens has the docketing stamp at the top that you saw from December 18th. So I think it is probably a technical error, and that's going to be charged to the court, even if it's technically nobody's fault and is just one of those technical glitches, it's not going to prevent Sarah Boone from being able to appeal. I mean, she's probably going to be pissed, and we're probably going to see another note from her to the court, but I hope that her appellate counsel, clearly being on notice that she is wanting to be very communicative, will hopefully reach out to her and let her know that her appeal is not going to be forestalled because of this. But I saw a lot of questions, and one of the things I like to do is try to answer those questions for you. So we will see Sarah Boone's appeal, I'm sure, moving forward, and we will probably see some more notes to the court from Sarah Boone. And I hope her appellate counsel will reach out to her and tell her exactly how long it takes to prep for appeal, and that we are now in a very slow-moving part of the law because so much needs to be reviewed. And speaking of people who probably aren't thrilled with the court, let's talk about Sean Diddy, P. Diddy, Puff Daddy, inmate number 739 Combs. I'm joking. I don't know if that's actually his inmate number, but the rest of the aliases seem to be appropriate. As I was sitting down to record, I saw news stories starting to come out that Diddy had been transported to medical out of custody and then was back in custody. I'm sure his lawyers will file something if they are not happy with the medical attention or care that he is receiving. They have made numerous bail motions. They had appealed the bail motions at one point. They withdrew that appeal, but we will probably see his attorneys make a note to the court. They have not shied away from letter filings. In fact, his attorneys filed a letter filing asking for the protective order in this case to be modified, and the court was immediately displeased. That's my characterization of the action that happened, because that docketed item immediately was stricken from the record after the government notified the court and said, hey, the filing to modify the protective order itself violates the protective order, so can we not? That motion was stricken from the record and a new, more redacted motion was filed. The court then denied that motion to modify the protective order and told the attorneys to work it out themselves. But now there is a superseding indictment, and with that trial date set for May, I imagine that we will be hearing from Sean Combs's lawyers in court at the beginning of next week. This superseding indictment was unsealed on January 30th. Of course, we knew that there was an ongoing grand jury. We had heard about it in numerous court filings. This superseding indictment added additional victims, but not much else. And so when I went through and looked at both the indictments side by side, we don't see new charges. We see additional victims added, but not a ton of other information. Does that change the case for Sean Combs? Yes, it does, because it's now not the argument from his defense attorneys, which we have seen over and over again, that this was a 10-year-long plus consensual relationship between him and Cassie, and this was not trafficking, and this was not abusive. And so now that there are more victims added to this indictment, will that change how the defense wants to present their case? Probably. And on January 30th, 2025, the government filed their letter notice to the court saying that there was a superseding indictment that contains no new charged offenses, but includes additional allegations in count 1, the charged racketeering conspiracy, and specifies certain victims relevant to counts 1 and 3. The government has already produced the vast majority of discovery associated with the superseding indictment and does not expect that the superseding indictment to affect existing pretrial deadlines. Well, the government might think that. We'll see what Combs's lawyers think. They have not responded to this in court yet. And then the government gives an overview about adding additional victims and extending the time of the racketeering conspiracy back to 2004 through 2024. They also added and specified the types of narcotics and controlled substances used, including adding psilocybin and methamphetamine. And with that, the government said we should be able to stay on track. But again, the government is always in a position of having more information at this point than the defense when they are unveiling a superseding indictment, because the government is the one going through the grand jury and presenting to the grand jury. The defense attorneys are not there. So them saying we can stay on track, we'll see what the defense has to say. And I still don't see how this trial goes forward in May. I will be very surprised if it does. And speaking of trial dates that will probably get pushed, we need to talk about all of the It Ends With Us litigation saga. Because yes, the court set a trial date for March 9th, 2026. There's a long way to go before we get into March of 2026. But so far, the attorneys have proposed a scheduling order that would keep that March trial date in mind. And the attorneys have had a lot to say with court, but one of the most notable things that you will see is procedurally, the cases have now been consolidated. That means that the cases are not just related. There is one case number and everything is combined. So the Blake Lively federal complaint and the Baldoni Wayfarer federal complaints are now combined in cross claims, essentially. So you will now see the heading will have all of the parties. Why does that matter? Well, you'll notice that it looks different, but also it keeps everything moving forward on one docketing number and it treats everything as cross complaints. But I also think it relates to whether or not we will see the California New York Times defamation suit dropped. And I think we will see the California New York Times defamation suit dismissed in the coming weeks because the New York Times has now been added to the federal lawsuit in the Baldoni Wayfarer party's first amended complaint, referred to me affectionately always as the FAC, because it's the FAC. The FAC is 392 pages in total. Remember when we talked about federal lawsuits, or a brief recitation of the facts? That's not where we're at anymore with these lawsuits. The original 179-page lawsuit, which was one of the longest suits I think I've ever seen, is now 224 pages to accommodate for the allegations against the New York Times, and then includes a 168-page Exhibit A that is a timeline lined out in their complaint. So what do we have going on procedurally in the federal case? We have the Lively lawsuit that was filed on December 31st, 2024 as the complaint for the Lively versus Baldoni Wayfarer et al. And then we have now the first amended complaint with Wayfarer, Baldoni et al. Versus the Lively parties, and adding in the New York Times. But wait, there's more. There's a lot. So much has happened in this case in the last few days. We've got a trial date set. We have the court bumping forward the scheduled conference that was supposed to be February 12th, and told the attorneys exactly what the court wanted to talk about. We're going to look at that first. Then we're going to take a look at, well, everything that follows from there. Who went to the press first is a question that is becoming more and more relevant, and I wanted to answer some questions that I've seen quite a lot about. Is there a request for a gag order pending? And technically no, but kind of maybe. We're going to talk about that. We have maybe some critical strategic errors that we need to discuss. And then, of course, some of my takeaways from the first amended complaint, which I'm going to list down below, because the website that we had been hearing about is now officially launched. So we have to talk about that too. Emily, I thought these were shorter podcast episodes. Right. Me too. I mean, it's shorter than a 7-hour stream trying to cover 360 pages of a lawsuit. So I guess there's that. So looking at the court's order, this is from January 27th, and it is the court bumping forward the pretrial conference and letting the attorneys know what they would like to talk about. The scheduled February 12th pretrial conference is rescheduled for February 3rd, 2025 at 11 a.m. in the Southern District of New York. Remember, this is federal court. Federal court is not televised. So the reporters in the courtroom are the ones that are going to be sharing what happens in the courtroom. The court says the parties shall means must. The parties shall be prepared to address the letter motion regarding pretrial publicity and attorney conduct at the initial pretrial conference. Pending responses to the order to show cause, the court plans to consolidate the matters, and the court has issued an order consolidating the matters. None of the parties objected. It makes sense to consolidate them. All of the parties have time to respond, and we're going to see all of that initial responsive filings. I don't know if I've ever seen more wrong headlines covering a case than in this case so far, but there are a ton of headlines that have said things like Lively and Reynolds or the Lively parties or whoever have made motions to dismiss. No, they haven't yet. They notified the court that they intend to make motions to dismiss, prior to the answer. Motions to dismiss at this stage are just that the four corners of the documents do not have enough information for there to be a cause of action. And there are a few things within the first amended complaint that maybe we could see, but likely not as to the Lively Reynolds parties, maybe as to the Sloan PR party, where it talks about whether or not there was extortion there, and we don't have any direct conversations between Sloan and some of the parties. As I mentioned before, to some of the causes of action, they are very broad as to the number of plaintiffs and defendants. And when you look at all of the plaintiffs suing all of the defendants on all of the causes of action, I think those will probably be narrowed down. I don't think that Melissa Nathan and Jennifer Abel, the PR individuals, were necessarily parties to everything by all of the defendants. So I think we will see some narrowing down of exactly which plaintiffs are suing exactly which defendants. Does that mean that everything is going to get dismissed? No. Do I think there will be some tailoring of this? Yes. Do I think any of the counts are going to get thrown out entirely? I think that's really unlikely. I do think it'll get pared down a bit. The defendants are now Blake Lively, Ryan Reynolds, Leslie Sloan, Vision PR, and the New York Times. So I do think we will see the New York Times defamation suit getting thrown out in California because it will now be consolidated into this case in New York, which makes sense. I'm still curious about the choice of venue for that lawsuit in California. I think that lawsuit for the plaintiffs might be a little bit of an easier road in New York and in federal court. California has a very strong anti-SLAPP statute, and I think that California case would get caught up in quite a substantial amount of litigation pre-answer that you won't see happening in New York and federal court. So when the court said, be prepared to talk about all the attorney pretrial publicity, we have seen a number of filings about the pretrial publicity. The headlines are all saying that the Lively parties are asking for a gag order. That's not specifically accurate. And I can understand how that interpretation was made, but it's not exactly what they're asking for. The Lively parties have asked the court to remind opposing counsel of the attorney rules of conduct. And we talked about this previously. I'm going to mention it briefly because it's going to end up in court on Monday with a who started it conversation. And the court is probably going to say, I don't want to know who started it anymore. Everyone needs to adhere to the rules of professional conduct, and there are limits to the types of statements or information that attorneys can put out. And the court will probably say, and I don't want to see anything that's not in filings in the public space. So when looking at what the parties had asked for specifically, the Lively parties said at the end of their letter filing to the court, quote, the endless stream of defamatory and extrajudicial media statements must end. It will not stop without this court's intervention. The Wayfarer defendants' efforts are being financed by a billionaire who has pledged to spend $100 million to ruin the lives of Miss Lively and her family. And then it cites back to the Lively case. It says Mr. Friedman is using that money, his roster of current and former clients, and a blatant media and social media strategy to assassinate Miss Lively's character in advance of trial. Accordingly, the Lively Reynolds parties respectfully request a conference at the court's earliest convenience to address the concerns raised herein in the Lively Reynolds parties' prior letters. All of these letters reference the attorney rules of professional conduct, which govern pre-trial publicity for the attorneys involved. However, the Wayfarer parties responded to this numerous times and said, contrary to the inflammatory allegations of the Lively parties' letter, counsel for the Wayfarer parties has not violated Rule 3.6 of the New York Rules of Professional Conduct. Rule 3.6a prohibits a lawyer who is participating in a civil matter from making extrajudicial statements that, quote, will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Putting aside that no such materially prejudicial statements have been made, Rule 3.6d creates an exception that allows the lawyer to make statements, quote, required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. So I imagine that at the hearing on February 2nd, there will be some arguing over who initiated what. And I have seen a lot of questions regarding the allegation from the Lively parties that it was in fact the Baldoni parties that leaked that CRD complaint first. They're not alleging that it was leaked to the New York Times by the Baldoni, Wayfarer et al. Parties. They were alleging it was leaked to quote unquote tabloid media. And I think the last time we talked about this, I said, I don't even know what they're talking about. Well, Law Nerds, you're amazing. And a lot of you were like, girl, this is what they're talking about. They're talking about TMZ publishing an article before the New York Times published their article talking about the fact that Lively would be suing Baldoni et al., but not publishing that CRD complaint. So as I had to go down the rabbit hole of who started it, because right now that's the argument in court is you started it, you started it. The federal court loves that. So for all of the law nerds that pointed out that there was a TMZ article, yes, there was. Let's talk about this timeline a little bit. And if you are curious about the timeline provided by the Baldoni Wayfarer parties attorneys on their website, it's going to be linked down below. We're going to talk about that in just a minute with the FAQ. Don't worry, we're going to get back there. But I wanted to take a look at this timeline because I know it's going to come up in court, and I wanted to answer the question for myself of what are both sides going to argue in this in court. Well, there was a TMZ article published on December 21st, 2024 at 4:54 a.m. Pacific Standard Time that headline reading, Blake Lively sues Justin Baldoni for sexual harassment, claims of wild behavior on set, exclusive. And then it was updated on December 31st, 2024 at 4:53 p.m. Pacific Standard Time. So TMZ did publish at 7:54 a.m. Eastern, 4:54 a.m. Pacific. Why does that matter? Well, the New York Times published their We Can Bury Anyone Inside a Hollywood Smear Machine article that is now behind a paywall that wasn't at the time on December 21st, 2025 at 10:11 a.m. Eastern or 7:11 a.m. Pacific. Why does this all matter? Well, some of the allegations in the New York Times defamation suit involved the New York Times pushing publish early. And did the New York Times go to print before the period of time they told the Baldoni Wayfarer parties they had time to answer? And actually, in the new filing from the Baldoni parties, we have the full email that the New York Times sent and have a bit more context about it, which is a question I had that we had not seen that entire email, and we had seen so much else. I was curious, and there it is. So curiosity answered. But all of that has to take into account that email from the New York Times, from my perspective. The New York Times reached out to the Baldoni parties on December 20th at 9:43 p.m. Eastern, 6:43 p.m. Pacific. So you have almost a 12-hour time span from the time the New York Times says, hey, we're going to print tomorrow with this 4,000-word article, and we will look at what the email says, because the email makes it clear the perspective that the New York Times is taking and giving a 12-hour window to answer on a Friday night right before the holidays. So who fired first is going to be one of those questions in court, because the Baldoni Wayfarer parties are going to say, we are responding to recent negative publicity. And there is an exception in the rules of professional conduct, which all mirror the federal rules, 3.6D. And we are just following that because we received an email and we were responding the best we can. And then the New York Times published early. I think the New York Times is still going to argue that they received a response and they said, we'll give you 12 hours for a response. And once they received a response, that they said, okay, we can go to print now. And I imagine at the New York Times, they were not thrilled that TMZ had an article up first. I wonder if that changed the New York Times perspective on whether this would be a paywall or not a paywalled article because TMZ went live first. And if you think who doesn't go live first doesn't matter in that world, it absolutely does to them very much. So I think we will learn more about the timing of all of this from the New York Times as they start responding to the lawsuits, because the New York Times is fighting two causes of action against them for promissory fraud and breach of implied in fact contract with regard to that time period between the 12-hour window and when they published. So it's really a 2-hour window that is being fought over between the time the New York Times went live and the time they told the Baldoni Wayfarer parties that they had to answer. Is it responsive? Did it stop being responsive? Did everyone respond? Is the court going to say, I don't care who did what before today, starting now, this is what we're doing? And I think that's probably what's going to happen. But there is quite a lot of back and forth between the lawyers over, we're just responding to what happened. And that's what all the sides are saying. But in litigation, we are seeing more and more, especially with public figure litigation, that this is no longer a game of chess. And as I'm looking at these filings are reading as if the lively parties lawyers are still playing a game of chess, and the Baldoni Wayfarer lawyers are like, we've moved past chess boxing and we are now in the octagon. And so it's cute that you want to play chess, but that's not the game that we are playing any longer. And the lively parties, I think, are showing that in their filings, or at least in the conversations that they are having with opposing counsel, because then we got this filing from the Baldoni parties that is maybe summarizing what the lively parties attorneys said. And then I promise we're getting to the FAC, but did this need to be filed in court in a letter memo to the court? No. Is it shade? Yes, it is. But is it improper to file it? No, it's not. But the request from the lively attorneys, as represented here, is wild. Do I think we'll see the lively attorneys responding to it in some way? Maybe. But we've reached audacity. So let's take a look for a moment, shall we? This was filed on January 30th with the court from the lawyers for the Baldoni Wayfarer parties in the lawsuits. They are now plaintiffs slash defendants, or defendants slash plaintiffs, however you want to say it. But I'm going to be calling the parties by the last names because it's just going to get confusing otherwise. They had a meet and confer as they were setting scheduling, and they filed a joint scheduling order to the court to extend some of the deadlines for things like discovery, answers, motions, and things like that. Totally normal, completely routine process. And then we get this letter that is anything but routine process. And probably a critical error. During a conference of the parties' counsel on January 30th, 2025, counsel for the Wayfarer parties requested the earliest possible deposition of Blake Lively. Counsel for Ms. Lively and Ryan Reynolds, the Lively parties, stated their objection to the Wayfarer parties' lead counsel conducting the deposition of Blake Lively. Specifically, the Lively parties' counsel indicated that they object to Brian Friedman personally taking Ms. Lively's deposition based upon unspecified statements made by Mr. Friedman. When asked to elaborate on the grounds for their objection, counsel for the Lively parties declined to do so. Now, if this is represented as it happened, we have a conversation we need to have. It goes on to say, counsel for Ms. Lively has made clear that Ms. Lively does not want Mr. Friedman to be the attorney who takes her deposition. Yeah, that's not her choice. We are unaware of any situation that would warrant the deposed party to have a choice in which attorney takes her deposition, right? Because that's not a thing. Parties to litigation simply do not have a right to dictate which of their opponent's attorneys may or may not take their deposition or perform any other aspect of the opposing party's case. Yes. Did this need to be in a filing? No. Could this have just been brought up at the hearing? Yes. But would the public know about it as much? No, they probably wouldn't. Putting it in a filing means that it is going to be discussed and disseminated. And that is the world of public figure litigation. But does a party get to choose who does their deposition? No. Do you want to tell a litigator that you don't want to talk to them? No. No. Nope. Nope, you don't. You know why? Because you're just going to make that litigator really happy. You are just giving them the gift of glee. Like there is nothing that those litigators are going to hear from that other than, really? Tell us more about what you don't want. It's like telling the internet that something annoys you. They're going to be like, bet this is not the way, and this is not going to go well. Now, could the parties have said, based on public statements, we would like to have a discovery referee. We would like to have a judge sit in. Yes, you can, but generally that request isn't made until after a deposition has gone horribly off the rails or a party has refused to answer anything. Sometimes you need a discovery referee to come in and be like, no, you have to answer these questions or the case is getting thrown out. Lively brought some of the litigation. She is now suing and being sued. You are not going to escape deposition. Depositions are going to happen. They are going to suck. This is not going to be a fun process for anyone involved. But telling the litigators that you do not want them to ask you questions is just chumming the water. It really is. In the civil cases that we have watched together, which aren't many, they are not often televised. Does it ever look like the parties enjoy the counsel that is doing the cross-examination of them? No. No, they don't. Not at all. But what it does is let the litigator know that you are already under their skin. And that is not a position of power you want to put opposing counsel in. But here we are. So I'm curious as to the full context of that. I don't know if we'll see the full context of that other than the hearing, but can discovery mediators, or in the rare exception, having a judge sit in on a deposition and make those rulings happen? I mean, it can, but it's not going to happen at an initial deposition, and you can't refuse to be deposed, and you don't get to pick who opposes you. You don't get to choose. You choose to sue or not to sue as a plaintiff. That's the only choice you really get to make in this. They can hire the attorneys that they want to. And in this case, the only way I see them not being able to hire the attorneys that they want to is because this is the type of litigation where I imagine there are a lot of law firms that probably have conflicts. So if you have law firms that have worked with Sony or Wayfarer or any of the Lively parties or movies that the Lively parties worked on, you're going to have attorneys and law firms that have conflicts based on potentially prior representation, current representation, because there's a lot of tentacles to all of this. But that's the attorney saying, no, there's a conflict here. That's not saying, I don't want to talk to that lawyer. Oh, that's not going to go well. I have no idea why this would be brought up on an initial meet and confer, but it's not going to go well. As litigators go, telling them that you're afraid of them just emboldens them. It's like running from a dragon at threshing. It's not going to end in anything but scorched earth, and that's really where this litigation is going. And now we have to talk about the fact, the internet, and where we go from here. The First Amendment complaint filed by the Wayfarer parties is one of the first documents filed under the consolidated case because the court just recently consolidated them. And then they brought in an additional defendant with the New York Times, which is why I think we will see the federal case being the controlling litigation of really all of this. And also why we're going to see it all moving forward piece by piece, because Lively is suing the Wayfarer Studios Baldoni et al. The Wayfarer Studios Baldoni et al. Are suing Lively, Reynolds, Leslie Sloan, Sloan's Company, and the New York Times. So there are three really groups of defendants as it relates to the Wayfarer parties, and the Wayfarer parties all at this point are represented by the same attorneys. So Lively, Reynolds, Sloan, and the New York Times, kind of three distinct groups of defendants. What I noticed first about this, of course, was that they added the New York Times in here and added the New York Times causes of action that mirror the California lawsuit. And then, of course, the additional internet rumblings that are now in court filings with a few specific notes. First, as we get into this First Amended complaint and point out some of the differences, because there is all of what's in the other lawsuits plus, and these are linked below and on the website that we'll talk about in just a minute. They get into the question of Nicepool and whether or not Nicepool was the Deadpool Wolverine movie taking shots at Justin Baldoni. This had been in the media due to a preservation notice and demand letter that was sent out to Disney and other outlets, but now it is part of this lawsuit officially. because it goes on to state, throughout this period, Reynolds and Lively continued to leave quote unquote breadcrumbs in their campaign for mocking and bullying Baldoni. On July 26, 2024, the film Deadpool and Wolverine premiered, starring Reynolds. The film contained a new character named quote unquote Nicepool, also portrayed by Reynolds. Reynolds portrayed quote unquote Nicepool as a vicious caricature of a quote woke feminist before concluding the character's arc with his violent shooting death at the hands of quote unquote Ladypool, a character voiced by Blake Lively. Upon information and belief, the Nicepool scenes were added to the movie and filmed in January 2024. Cue Disney execs everywhere going, you're not pulling me into this lawsuit. Well, yeah, because it's now alleged. Who's getting deposed? Everybody. Everybody's getting deposed. Disney, Sony, everyone. They go on to information and belief their way through the allegations here because discovery has not happened yet, that the Nicepool scenes were added and filmed in January 2024 after the January 4th confrontation in Reynolds and Lively's apartment, and were intended to be a transparent and mocking portrayal of Reynolds's warped perception of Baldoni. Now, is this all written in advocacy? Yes, it's a complaint. It is written completely from the side of the party. Have there been responses to any of this? No, there's not going to be responses to this until after there's motions to dismiss. But we are now seeing the things that are being discussed online moving into the filings of the parties, and in high-profile litigation. That does not surprise me because the attorneys will use the crowdsourcing of online to their advantage, or at least when they are clever, they will. Not all attorneys will do that, but we have seen it in case after case after case where the internet becomes the paralegals of one side or the other, or both, noticing things in a case, giving commentary on a case, and seeing the case from different angles than the lawyers do. They go on to include pictures of Reynolds as Nicepool and Baldoni. I don't know. I haven't seen Deadpool, Wolverine yet. I haven't seen any of the movies we're discussing here. I've been reading Dragon books and watching Traitors because Boston Rob and Dolores Catania. As we get into the additional information with regard to this lawsuit, Nicepool is one of the first, hey, the internet said, and now we say. But it also gets into something that a lot of you brought up in the comments, that there had been questions, comments, TikToks, speculation, proof, thoughts, all the things about when the New York Times article was actually populated. And that made its way into the first amended complaint too. In talking about when the New York Times article was prepared and dropped, and the coordination, they say, between Lively and the New York Times, they go through a brief timeline, but they also get into the metadata that had come to light online and actually credit the internet with that discovery. They say in the first amended complaint, paragraph 263, quote, the 4,000 plus words of the New York Times article dropped less than a day after Lively apparently filed her CRD complaint. It's interesting at this point that they say apparently, because we now know that Lively's attorneys sent the CRD complaint the day before, the same day that the New York Times reached out for comment to these attorneys. But I digress. They say the close coordination between Lively's team and the New York Times, likely over a matter of months before the CRD complaint was filed, is plain and now has been proven beyond doubt thanks to internet sleuths from around the world. So the wink and a nod between this first amended complaint and the internet being like, oh no, we're receipts, timeline, proof, everything. The internet has questions. They say upon information and belief, because of course they have not done discovery yet, and the upon information and belief is doing a lot of heavy lifting here, because this is what they think, but they do not know for certain yet. And it's not something their client can tell them. Their client is not the New York Times. They say the New York Times loads images and other data files for its website using a file naming convention that indicates the date that the data file in question was created or loaded onto the website. As members of the public soon discovered, the URLs for various images of the article point to dates as early as December 16th, 2024. What I don't know and I'm interested in is, when did that article go back paywalled? I have questions. When did the paywall pop back up? Was it after this? They go on to show images with the naming file conventions for the lead image that says 2024-12-16 and other images from the article as well. They go on to say, as other members of the public pointed out, web crawler data appears to indicate that the PDF of the CRD complaint linked within the article was uploaded to Times servers even earlier, specifically using a search engine to search for the CRD complaint within the Times static document repository, where the CRD complaint is stored for referenced by a link in the article, shows that a web crawler, a program that scours the internet to locate and catalog websites and files, recorded the CRD complaint PDFs as having been uploaded as early as December 10th, 2024. Now, you might be saying, yes, see, or you might be saying, why does it matter? Well, getting into the back and forth of who was doing what and when, and who had a PR team working against whom, it has become a central point of conversation, not only with what the lawyers are saying outside of court, but also what is being alleged with regard to the defamation of the New York Times, how much collaboration there was between the Lively parties and the New York Times. And it goes to that defamation suit, but it also is almost what you would see in an answer to a lawsuit saying, no, you said there was a smear campaign against you, but the smear campaign was against us. And this had all died down, and you just brought it all back to life with this article dropping. The lawsuit goes on for a number of pages in this first amended complaint to talk about other instances where they see that. Well, after this dropped, of course, it dropped publicly on the website that we heard Brian Freeman referring to numerous times, that there was going to be a website with everything, all the text messages, all the information. And lawyer brain went, I would love to see everything. However, I don't know if that's really something that you can do while you're in litigation. I think the federal court, would not take kindly to it. And I think it would really be pushing the boundaries, if not over the boundaries, of some of those pretrial litigation rules. However, when it is in court filings can be made available to the public. Court filings can be accessed on a website, or they can be provided to the public for free. And that's exactly the direction that the parties seem to have chosen to go in by putting the legal filings from their side on a website, making them available to the public. You don't need a Pacer account. You don't need to pay for them. They are just publicly available. There is nothing improper about making legal filings available. Does that make all the text messages available? No. But does it fall more squarely within the rules that Lively's attorneys are complaining about? Yes. So that will be linked down below if you want to read all 300 pages for yourself, if you haven't already. And the New York Times immediately responded to numerous media outlets, including Variety, saying, the Baldoni Wayfarer legal filings are rife with inaccuracies about the New York Times, including, for example, the bogus claim that the Times had early access to Miss Lively's state civil rights complaint, a Times spokesperson said in their statement. Quote, Mr. Baldoni's lawyers base their erroneous claim on postings by amateur internet sleuths who, not surprisingly, are wrong. Well, New York Times, if you thought the internet was your friend before, welcome. They go on to say the sleuths have noted that a version of the Lively state complaint published by the Times carries the date, quote, December 10th, even though the complaint wasn't filed until more than a week later. The problem, the date is generated by Google software and is unrelated to the date when the Times received it and posted it. That doesn't make sense to me. Blame Google? How can Google date something that doesn't exist, like in absentia? I have questions. I mean, I'm not a tech expert, but I just have some questions there. It goes on to quote Attorney Friedman saying that if they can prove that the Times and Lively's team had early discussions outside the scope of the CRD complaint being filed, that he is going to be arguing in court that that would strip away the legal shields that protect the New York Times, because again, the New York Times and others can accurately report on what is in legal filings and shield themselves. Litigation privilege extends to accurately covering the litigation. So when we are seeing the import of breaking down when all this happened, you can see why. Getting at and after the New York Times is a central part of this lawsuit, in addition to going after the lively parties. So trying to ascertain when and how those conversations took place, and if it was before that CRD complaint, you have the reasoning from Brian Friedman's own statement there that it's because they want to pull back that litigation privilege that otherwise covers the accurate reporting of legal filings. And legal filings, again, can be allegations and shade. So when everything gets thrown into a filing with the kitchen sink, courts generally don't tell a party that they have to pare back their complaint, though it can happen. We actually saw it in another one of Brian Friedman's lawsuits where there was a motion to strike parts of a complaint from Tom Sandoval in the Tom Sandoval-Rachel Levis litigation, Rachel represented by Friedman and Garrigus, but you saw the court actually strike parts of the complaint because they didn't go directly to what was being alleged. So we saw a lot of that complaint get pared down. And yes, that can happen, but it doesn't stop an outlet from reporting on what is filed in legal documents, which is why I think when we see the website that the lively attorneys have already complained about in their filings to the court, when we see that website going up with the legal filings from the Baldoni Wayfarer side, it's because those documents are protected. They are extensive, but they are just the legal filings, providing things on that website that are outside of what might happen in court, that are things that might not come into evidence. That is really a different matter, but the court and opposing counsel can't really cry foul of making publicly available public records that they filed. So where does that leave all of this? Well, we'll see what the federal judge does on Monday, which will be after I record this, but likely before it goes live because I was so late this week because everyone has been sick. But if there are updates, will be in the description down below. I imagine that the court will tell the attorneys that he would like them to all bring it down a notch, which we've also seen in the civil case with Spyro fighting with Attorney Busby with regard to Jay-Z in that civil lawsuit. Federal judges tend to have low tolerance for excessive bickering. Though if you do want to see a judge that has zero tolerance for excessive bickering, if you are not watching the A$AP Rocky trial, you will see that there where both sides just start squawking at each other and the judge is like, stop it, all of you. It's hard to watch because every 4 seconds, the judge is just yelling at everyone to stop. I'll try to summarize that trial when it's done, but right now it's just the attorneys fighting with each other and the judge yelling at all of them to stop. And it is difficult to follow. I imagine that the jury also feels like it is difficult to follow because of that. But federal judges have low tolerance. And at some point, someone's going to say this level of hyperbole is unhelpful and we want this case to move along. So do I think we will see more on the website from the Baldoni Wayfarer parties? Probably not more than legal filings. And I think that that's appropriate. But did the discussion of whether to put up the website prompt Lively's side to file in court saying, Your Honor, make them stop it? Yes, it did. And it was not well taken that they had filed saying to the court, you can't just put everything that may or may not be evidence out on the internet. And well, legally, no, you can't. That's not really the threshold for this case at the moment, but it is the threshold for me. So I am going to keep following the legal documents, breaking down what the attorneys are doing in all of this, because these two sets of attorneys are operating in very different ways, and we are seeing that be received in very different ways. The type of litigation that plays out with high-profile public figures is different than how we see other litigations play out, and civil litigation is a world away from criminal litigation, which is a lot of what we see so much in the public eye because those cases are more likely to be streamed, televised, and covered. Civil cases often aren't, and cases like this in federal court, there is no access outside of those who physically show up in court, which I find incredibly frustrating. Just let us see what's going on, but we're not going to in this case. And when lawyers push the boundaries of what the rules are in court, we will probably see the court checking all of the sides. But then again, we have seen in some of those filings, Lively's lawyers make some very interesting choices, including sending out a cease and desist to the Baldoni Wayfarer lawyers on December 20th. And I would imagine it was within hours of that email from the New York Times, which I said I was going to mention and then hadn't. Some of the interesting takeaways for me seeing the full context of the email from the New York Times is that first, the New York Times email seemed to go to primarily Jennifer Abel. It looks like there may be another email address that is redacted out, but this is addressed to Miss Abel, the PR agent. And it says, and I said this the last time I covered this, if this is represented as it is, and now we have the entire text of the email included in this extensive timeline exhibit, saying, Miss Abel, we are reporting about a crisis communication operation conducted on behalf of Justin Baldoni, Jamie Heath, and Wayfarer Studios to protect their reputations and harm Blake Lively's, as described in a legal complaint filed today. Our reporting found that you participated in the effort, which was undertaken last summer out of concern that complaints Miss Lively had made during the filming of It Ends With Us. And we do see some of that in this exhibit as well. We see conversation about Lively bringing up issues with what is being referred to in these filings as the sexy comment. We see that in Lively's complaint as well, that those were brought up as early as June. And we see in this timeline the Wayfarer party saying, we discussed this and thought it was resolved in June when it was brought up, but it came up again in that November meeting. But we do see that laid out more fulsomely in the Baldoni Wayfarer party's timeline. They go on to say, we have learned that Ms. Lively filed a legal complaint against you, Baldoni, Heath, Steve Sarowitz, Wayfarer, Melissa Nathan, and Jed Wallace, alleging sexual harassment, retaliation, aiding and abetting of harassment, and retaliation, among other claims. The complaint claims misconduct on the part of Mr. Baldoni and Mr. Heath during filming, including repeatedly violating physical boundaries and making sexual and other inappropriate comments. What I noted about this email is that it did talk about the legal complaint being filed today, and then it goes through and lines out specific text messages and emails. And it goes on to say the complaint includes extensive private text messages and emails that she obtained through a subpoena and that document the crisis communication operation. They include exchanges involving you, your team, Baldoni, and Mr. Heath. The New York Times reviewed these along with other documents. And then they say, we are seeking your response by tomorrow at noon Eastern, and list out basically what is in the complaint point by point by point in a pretty extensive and long email quoting a lot of the text messages that were not only in the complaint, but also in the article. Now, do I think these text messages were necessarily provided by Lively's team directly to the New York Times? There are multiple ways that could have happened, including from the PR agent Jones of Joneswork, who is the one who had Abel's phone. Could that have happened? Yes. There's multiple ways that could have happened. But with regard to the CRD complaint, there aren't really multiple ways that could have happened. That was not a public complaint. That was an administrative complaint. So it was interesting to me to go through how thoroughly that email went through point by point what was going to be in a fairly extensive article. It is going to be of paramount concern for the Baldoni Wayfarer parties when that complaint was provided to the New York Times and how. And the New York Times is going to fight to not disclose that information, claiming that they are privileged as a news reporting agency and they do not have to turn over their sources. They do not have to turn over when, and they are going to fight discovery at every turn. And speaking of at every turn, after court today, I knew I had to add an addendum to this not so quick episode of The Emily Show because there are a few key things we learned from the first hearing in this case today. Some of my big takeaways. First, the New York Times has not been served yet when they got added in as a defendant to the case. And we saw that attorneys for the Lively party said this case may need to be unconsolidated, even though the court just consolidated the cases together, because of the fact that the New York Times is now a defendant who is not part of the Lively litigation, only now part of the Wayfarer Baldoni litigation. And so they might go back to being related cases, not consolidated cases. We will see more on that in court down the road. But as I said earlier in this episode, Brian Friedman did indicate to the court, he is the Baldoni party's attorney, that he intends to dismiss the case in California and proceed with the New York Times litigation in federal court in New York. And now also in federal court in New York is that Joneswork PR lawsuit that had been really hard to find on the docket in New York State Court. On January 27th, that case was removed from New York State Court and moved into federal court and has now been related to these other cases. So the Lively federal lawsuit, the Baldoni Wayfarer federal lawsuit are consolidated into one case for now. The New York Times has been brought in. They are part of those two litigations. And now the Joneswork versus Abel, Nathan, Wayfarer, Baldoni et al. Is now a related case, meaning it won't go to trial at the same time, but it'll be going alongside the other case because a lot of the discovery is going to overlap. But the consolidated cases mean those go to trial at the same time. All of them being related together mean they come into court at the same time. Discovery moves ahead at the same time. And we heard a lot about discovery in court today because there was fighting over that wild and audacious request about who's going to do Blake Lively's deposition. And the court reminded the attorneys, like, that's not your choice, and indicated that depositions are not going to be going forward yet until they get the document discovery done, which is the normal process of things. So the court said, hold up, wait a minute. You're not doing depositions yet. We need to get through discovery, and you are not going to be moving to take Lively's deposition. The court also indicated that if a protective order needed to go into place for discovery regarding the depositions, that needed to be filed by March 11th. And if there were two different versions of the protective order, that the court would then deal with it in March. That's not unusual. We've seen the protective order. We talked about it in this episode with the Diddy case. A protective order covering discovery, especially in a high-profile case, is the normal course of litigation. We also saw the attorneys, of course, fighting over who went to the press first, who said what to whom and when, and the court made an interesting note about that, as reported by those in the courtroom, including Inner City Press. When the attorneys for Baldoni, Brian Friedman, started talking to the court about the fact that the attorneys for Lively, he says, went to the New York Times, quote, months before any filing was made in this case. The New York Times, giving 12 hours notice, put out an article that was completely devastating. And the judge seemingly cut in and said, you don't have enough evidence that Mr. Gottlieb, the attorney for the Lively parties, was behind that. So the court, as I thought, is not having any of the attorneys back and forth in court or the attorneys back and forth outside of court, and said that if this case was going to be litigated in the media, that he was going to bump the trial date forward, which would not be easy for any party to accommodate. And when the court was made aware of the website that has since gone up, which is linked down below, we heard the attorneys for the Lively parties arguing that they are going to be moving to strike that 168-page Exhibit A addendum, arguing to the court that you can't just attach a factual narrative. The court asked the attorney for the Baldoni parties what was the purpose of that. And when the Baldoni party's attorney, Brian Friedman, said, it shows the basis of our claims, it's going to make discovery easier, we're putting it all out there, the court responded, that's what the federal rules are designed to prevent, and reminded the attorneys that there were rules and that the court would be strictly applying the attorney rules regarding out-of-court pre-trial statements. And the court put out an order today reflecting what happened in court, specifically noting that motions to dismiss would be coming and that Rule 3.6 of the New York Rules of Professional Conduct is adopted as an order of the court and shall apply to all counsel, and that breach of the rule may be punished pursuant to Rule 16F of the Federal Rules of Civil Procedure. That is a rule that governs all attorneys. This is the court indicating that they do not want this case litigated in the court of public opinion. The attorneys in court said you can't unring the bell, and you can't. You can't put the ship back in the horse at this point. The court also said he doesn't want to really have a side quest, my summary, trying to determine what attorney statements are proper or improper. Federal courts do not like to play with this stuff, and they are going to tell all the attorneys to knock it off. I imagine we will still see letters back and forth of this attorney did that and this attorney did that, and at some point asking for sanctions. But I don't think we're going to see as many public statements made, except this was filed. This is what happened in court. We're happy with the outcome of this hearing, and this is what's happening next, keeping it really to the documents filed in court. And it seems that the court might be inclined to strike that Exhibit A. And I imagine we will see other motions to strike out other parts of the 200+ page complaint filed by the Baldoni Wayfarer parties. And at the end of the hearing, the court noted, if it turns out this ends up being litigated in the press, I may accelerate the date of trial, as I mentioned. The court went on to say, unless this case is settled, a jury will speak. And Brian Friedman said the damage is done before the jury speaks. And the judge said, I get it, and then adjourned the hearing. And I think this is what both sides are concerned about in these types of litigation, is that who has damaged whose client and how we go forward from here without that damage accelerating. So with all of that, there is a lot of litigation to come. At least all of these cases are really now before one court. It looks like we're going to be narrowing down to really 3 lawsuits, 2 consolidated, 1 that's related, all in federal court in New York. And federal court in New York doesn't have TV, doesn't have streaming. And so we're going to have to wait on reports from what happens in court when they are back. But the letter filings, I'm sure, are still going to be snarky. So now let's get back to the outro that was previously filmed as I say goodbye. And with that, I will see you in court, Law Nerd. Don't forget to get the Law Nerd app so that I can keep you in the loop. I am traveling, so when I will be covering court is still a bit up in the air, as I will be shortly. But I will keep you in the loop on what's going on with this case and others. Next week, there will not be a Quick Bits episode due to travel, but I will see you on the live streaming channel because there is lots of court to cover. Thank you for being here. Thank you for being a Law Nerd. Stay well. This flu season is a bugger, and may the odds be ever in your favor. Bye. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.